Hi everybody, welcome to this month's Fireside Chat. My name is Aleks Kowalski, one of the directors of ARPAS-UK, and joining me for this Fireside Chat around intellectual property and patenting is John Hawtree, Patent Director of HGF. Hello, John.
Hi, Alex.
Thanks for joining us. No,
thank you for having us.
No, you're very welcome. So this conversation is all around, as we said, about patents, intellectual property, primarily obviously within the drone industry. But before we start, maybe a little bit of a background to yourself, HGF, and kind of what you do on a kind of professional day-to-day basis.
Sure. So yeah, my name's John Hawtree. I'm a patent director at HGF Ltd, which is a patent attorney firm, or a full IP firm, I should say. So essentially day to day, I'm a patent attorney. So that means I'm in this country, I'm UK qualified and European qualified. That's what you tend to do if you're from the UK. And that's really about helping clients to protect their innovations and their inventions that they would bring to us. In terms of the technology areas that I've worked in, so my academic background is physics. Then of course you do the legal training on top of that. And so I've got about 18 years experience, and a lot of that's been spent in private practice. So that's a really diverse technology sector, or diverse technology sectors of clients that would come to you. So aerospace, definitely yes, but also automotive, software and hardware, particularly in a telecoms context, batteries, machine learning more recently, even some medical stuff. So yeah, really diverse sort of technology range. But the thing that I really enjoy doing the most is the aerospace side. So I'm the head of the aerospace group within HGF. And a lot of the reason for that is that I spent 4 years internally with Rolls-Royce, the gas turbine engine manufacturer. So plenty of experience with gas turbine engines and combustion systems. But I've also done eVTOL and more recently drones. So fantastic to be involved with you guys. HGF, so full service IP law firm. So that's helping advising clients on patents, trademarks, copyright designs, and helping them obtain those rights. But then also somewhat unusually, we have IP solicitors within the firm as well. So they help with the transactional side, so agreements between clients related to IP, and then also anything related to litigation, of course. Offices all over the UK. So I'm in the Birmingham office personally, but plenty of offices north and south of that, and offices all across Europe as well. And yeah, very pleased to be ARPAS members and being more involved in the drone space.
No problem. Thanks, John. I guess starting at the beginning, for kind of listeners who are maybe less familiar with IP and patenting, we've all heard the terms, but kind of from a kind of listener's perspective, what would we mean by intellectual property, patenting, trademarks? Just as kind of basic definitions before we get into some of the technicals around the areas of the drone industry that might be of interest.
Yeah, sure. So intellectual property is about protecting non-tangible assets. So not physical things, not buildings, not stock. It's about ideas, protecting ideas, and fruits of the mind, essentially. So it can be inventions, it could be signs of origin, like trademarks, the kinds of things that you'll be familiar with, whether it's jingles or logos or words, even colors. Literary, dramatic, musical, artistic works tend to be protected by copyright. And then the aesthetics of things, which tends to be protected by design. So the aesthetic appearance of something, handbags, Coke bottle, anything like that. So there's lots of these sort of intangible assets that you can protect. And then there are these 4, 5 different IP rights that you can use to protect them and are appropriate for each one. And then some of these rights sort of arise automatically, but a lot of them don't. You need to apply for the rights through a registration process, and that's really a big part of where we come in, is helping clients to get hold of these rights, to draft the patent application, to draft the design application. And then,
got you.
Yeah.
From your perspective so far within the kind of drone space, what have been the initial areas where maybe people have looked to patent? Because again, our members are very diverse, from kind of small operators through to people who are just getting started with drones through to larger manufacturers. Is there, for example, DJI is obviously the standard kind of flag bearer in terms of the site drones. is it very much a manufacturer's domain, or are there other areas in which you're finding patents or areas that people might be of interest to do work?
Yeah, no, very, very diverse, all the way from the sort of the platform itself, and so technologies around, you know, the batteries, the propulsion systems, the airframe, anything like that, and then through to the software that controls navigation, the communication systems, image processing, and then, you know, communications with satellites, all things like this, and yeah, you can protect both products and methods, and there's some scope for protecting software as well, the applications of software. So yeah, it's really diverse, and there's a lot of convergence of technology, obviously, at the moment, with a lot of companies in different sectors using battery technology, electrification technology, using AI. So yeah, convergence of technology as well.
And without getting into individual company, say, names or details, are there certain patents that have kind of gathered attention that, you know, for example, if you develop a good patent or a solid patent, do you find that there is a revenue stream to be made, or is it often inflating or looking to increase the value of the business because you hold the patent to a certain IP, for example?
Yeah, it's a really good question. It's a bit of both, really. So there are some recent examples, particularly within the eVTOL sector, of whole patent portfolios being purchased by companies. So there's, I think, Archer recently bought Lilium, I think, or bought their patent portfolio. And GoPro sold their patent portfolio relating to drones to Skydio. So yeah, you know, you can have whole patent portfolios being sold. You can also, of course, license technology to individual inventions, particularly when it's patented. So yeah, sorry, what was the and yeah, protecting the value of the business, definitely. So obviously maybe the primary purpose is to give you that up to 20-year monopoly, protecting a piece of technology that you've invested in developing, and then that is obviously, then if you've protected that, that's fantastic if there's any sort of mergers or acquisitions, because the buying party or the investing party, if they're interested in your innovative business or the technology you've developed, they want to know that it's not just free to use for somebody else, that thing that you've invested in.
Now the dichotomy of the drone industry is obviously, you know, a lot of companies are trying to go beyond visual line of sight to provide kind of business as usual services to clients, which, you know, we're still at that kind of tipping point where the government's trying to create new strategies, new plans, but the industry's not quite there yet. For example, how many drones do we see on a daily basis? Not that many. So the question is, I guess, is at what point do you get to the position where maybe a patent starts to inhibit, for example, collaboration, business opportunities, and how do companies manage that I guess, challenging space where you've got an idea, you want to patent it, at the same time, if you do it too quickly, potentially you're restricting, you know, business development at a wider industry level?
Okay, so yes, so there are collaborative systems around patents that exist already. So obviously the primary purpose of a patent is to try and reward that innovation and encourage innovation. So if you're going to invest time and effort and resources into a particular technology and you develop something, you want to know that you're then going to be able to use it, and that your competitors are not necessarily having not spent that money and effort, or at least only if there's some reward for you in terms of licensing revenue, for example. So in a competitive situation, it would be quite difficult to have a good, fair system without patents in place. But there are systems or solutions that people have come up with in exactly those kind of situations where, for example, there's mutual benefit in collaborating on patents. So you can have something called patent pools, for example, where a number of organizations will put their patents into a pool of patents and say, okay, within this group, everybody's free to use this. You can also have something called standards essentials patents, which is particularly prevalent in the telecoms industry, where you want a certain amount of standardization, so that everybody's using the same basic fundamental principles. So then in that kind of a system, that the companies that have their patents, they'll put those patents into, again, effectively a pool, but that's not then free to use. It's that they're saying that these patents, because they relate to this core technology, will say that we will license them. whereas that's not normally the case that you would have to license them, or that, but they're saying we will, as long as it's on fair and reasonable and non-discriminatory principles, essentially. So there are, in different sectors where there's this need for a certain conformance around particular technology, those kind of things have been done.
Okay, very interesting.
Where there's mutual benefit, yeah.
No, without getting into individual company specifics, I appreciate we can't go in that direction. But I'll give you an analogy. If, for example, an organisation decided to patent a wheel to say it's round, are there sometimes places where patents are, for example, not particularly helpful or can inhibit the growth of an industry? So, for example, one example in the drone industry where this kind of coaxial drone technology, which has been patented, and other organisations use it regularly, but then organisations are trying to say that's our patent. So it's a very difficult one then for an organisation that's developed something without realising they were infringing a patent, for example.
Yeah. So, okay. So the question of whether or not there's awareness around that a patent exists, let's say, and whether or not you're infringing it. So all patents are published both at the application stage and when they're granted, so that they are available to the public. And that's part of the quid pro quo, is that you get this monopoly, but you also have to make the public aware of the technology in a way that they can use it, essentially. So it is out there, and again, that's a service that we provide. It's freedom to operate service, essentially, where we can search for relevant patents to what you'd like to do, advise on those patents, and then sort of give advice as to the best action going forwards for you as a business. Whether or not, so something like the wheel, you definitely do see sometimes frustrations arising from misunderstandings, I think. So a patent document is laid out in a very specific way. And a lot of times you will see engineers, for example, will read a patent application and perceive that it's protecting something very, very broad, and then get frustrated that they think this has been around for a long time and it shouldn't have been protected. And that can happen, but the fundamental way that the patent system works is that the patent should only be granted if the technology is novel and inventive. It's this kind of two-pronged criteria. So it should be something that's noticeably above and beyond what's already out there in the public domain. And it's open to challenge throughout its life as to whether or not that is the case. So sometimes, taking your example of the wheel, my challenge often back then would be, is that a wheel has been discussed somewhere within the patent application, but actually within the claims, which are the critical part that defines what's actually protected, there's something quite a lot more detailed than the wheel, and it's actually to do with the particular nature of the attachment mechanism onto the car and the way that integrates with the braking system or something, So yeah, you can definitely get these kind of situations.
Okay, I mean, you've led us to that point. Kind of, if I step back a little bit, the practicalities of applying for a patent, what are the different components of it? You've mentioned claims and so on. If I've never done a patent before, what's the journey through that? What can I expect to have to do in order to get a patent approved?
Yeah, okay. So let's say that somebody comes to us as a fresh client. We'd probably be looking in general at their IP strategy with them, first of all, thinking about who their competitors are, what the key bits of technology are within their business. If they lost this, then would it be critical? Perhaps what they've already got, may not already know that they've got in terms of IP that's arisen automatically. Thinking about their key markets, where they're manufacturing, where they're selling, and the most valuable parts of their business. And then assuming that we've found a piece of technology that is a key piece of technology that they ought to protect, then we would, in collaboration with them, draft a patent application on their behalf. And then that gets filed at a patent office or multiple patent offices, depending on where they want the protection, because it's jurisdictional, it's country by country.
Right.
And then we do what's called patent prosecution. So that's basically a back and forth with the relevant patent office, in collaboration with the client. And that's basically the patent office potentially saying, we don't think this is novel and inventive because of this piece of what's called prior art, something that's out there in the public domain, a previous patent, another document. And then we, as the patent attorney, may or may not agree with the patent office, and we essentially potentially we might be arguing with them, or we might be suggesting to the client, yes, the Patent Office has a point here. Can we amend to narrow the scope of protection or change the scope of protection that we're seeking based on other material that's in the patent application? So this is the prosecution, the various rounds of examination that you might go through, and typically the patent application would be somewhat narrowed in scope in terms of what it's looking to protect through that process, until the Patent Office agrees that what you're now trying to protect is novel and inventive. And that's sort of a multi-year process typically.
Yeah, having gone through a patent myself, my recollection was, for example, you've got a new drone that you want to patent. You've come up with a new design. For example, you could issue it on a piece of paper, but then you might ask to break that down, and ultimately from 12 spinning props, inverted, whatever, it focuses very now on through I think a series of claims, as you call it.
That's right.
And certain claims get rejected, and eventually you filter it down to 1 or 2 claims that are still valid within the system.
That's right.
Like a funnel of some sort.
Very, very exactly right. Really good description. So it's a cascading series of protections of narrower scope, and so you start with the broadest scope that you think you might reasonably get protection for, that might reasonably be considered novel and inventive, and then typically the Patent Office will come back and say, here's a pre-existing patent or a number of patents that the Patent Office looks to mosaic together and say, well, if you take this bit of technology and this bit of technology, I would say your invention's obvious. It's not inventive, not sufficiently inventive.
Okay. And if I'm coming back to a certain question in a minute, but if I extract outwards, for example, if I look at 2 airlines in the United Kingdom, 2 commercial airlines, I imagine they have very few patents. It's the business model that probably is more of interest to them. If I'm a drone operator, for example, I imagine it's very difficult to patent a business, for example, a business model, or is that something that can be patented in terms of we're using the same potential drone, same batteries, but I've got a couple of clients, I've got a particular way I do things. Is that something that is also patentable, or is very much, as you said, ideas, hardware, technology, software, than a process as such? And if it is patentable, do you have an example of that you potentially might be able to give us?
Yeah, sure. So yeah, you're again very astutely touching on an area, that the third area after novelty and inventive step. Another criteria is that the technology mustn't relate to excluded subject matter, what's called excluded subject matter, and that's certain things that aren't patentable, have been agreed aren't patentable, and that includes, in principle, business methods, programs for computers, mental acts, methods of doing business, among others. But those very typically come up, and it's a bit of a grey area. And so very often there are ways to find the innovation within that is within those kind of ideas that are protectable. So, for example, you could say programs for computers are not protectable in principle, but the application of them can be. So whilst you might not be able to protect the raw software for an ABS system for a car brakes or something like this, the fact that you can protect the application in the sense that it improves braking performance, it operates the brakes in a particular way to reduce the stopping distance. So yeah, not raw code in and of itself, that's protected by copyright up to a point, but the applications, the technical effect arising from a piece of software, you can. Business methods, generally more tricky, but again, if there's some technical contribution within your business method that results in some piece of technology working better, some system working better, there may well be something within that. So yeah, I think generally speaking, if you're uncertain but you think you've got something that's giving you an edge within your business, it's probably worth a conversation with a patent attorney to see if there's something within that that's patentable.
Okay. One of the areas you mentioned, we talked at the beginning, was kind of trade secrets. When you issue a patent, I think it obviously is in the public domain. So are there circumstances where you do not wish to potentially develop a patent because then some of your idea is in the public domain? And how do you develop that balance between a trade secret versus putting it through a patent?
Yeah, so trade secrets are more about protecting things contractually, and the way that you set up your organization for a degree of secrecy, essentially. So I think like a very famous example of that is, I believe that Coke have never patented or otherwise protected the formula for Coke, the drink. and they've managed to keep that secret within the organization all of these years. And so if you consider that you can do that, and you want, for example, your technology to have it's extremely long-lived technology, so it's maybe longer than 20 years, which is the maximum term of a patent. And if you think that you genuinely can keep it secret, even where you've got employees potentially going elsewhere and breaches of contract potentially, but yeah, there are certain situations if you've got an invention very embedded within software code that it would be very difficult to extract for a third party. Yeah, that might be the kind of situations where you'd prefer to use trade secrets and just keep it very internal and secret. The only other thing to say about that is that the trade secret model doesn't protect you against independent recreation. So if somebody comes up with the same idea as you, if somebody independently comes up with the recipe for Coke, you're not protected, they're free to do that. Whereas with a patent, it's a monopoly. So if you're the first one to get there, if somebody else independently creates it afterwards and can prove, well, I was actually completely oblivious to your technology, that doesn't matter. You can still prevent them from doing it in principle.
When people start a business, there's often this idea of, well, I've written it down on a piece of paper, or it's on a document or an email, and therefore I own some sort of intellectual first claim, so to speak. Does that thing even exist, or is it a misnomer? And the reason I mention it is I'm getting to this idea of copyright. Again, I have to explain what copyright is to the audience, but
yeah,
in terms of, I had an idea, I wrote it down somewhere, it exists already. Mm-hmm. Is there any value in having that in some capacity, even without necessarily going down patenting or trade secrets or anything like that?
Yeah. So it depends what it is. So if it's something like a literary, dramatic, musical, artistic work, then very much so getting it fixed in some kind of medium, whether it's paper or digitally, is very important, because that's essentially how the copyright arises in the first place, as long as there's sufficient originality. And so, yes, there is. I think that's true when it comes to copyright. There's not really value in that, certainly not in the same way as regards patents. Patents are a registered right, and so you've got to apply for it, and it exists from the point when you apply for it. So okay. Yeah, it depends on the right. Copyright, yes. Patents, no, not really.
Okay. I guess kind of moving on now into the drone industry, where do you see the kind of bigger trends and specific tactical trends where people are looking to either develop patents or inquiries are being made? In which areas? You touched at the beginning, kind of motors and batteries and so on, but are there certain areas where you're finding there's a bigger level of interest to develop certain patentable technology?
Specifically on the drone side, I mean, I think very much around the software relate, like BVLOS, as you say, the various application technology, imaging technology. There's obviously agricultural imaging technology going on, wayfinding, anything like this. There's so much work going on in that kind of software space. But then also, even still, the hardware. We've done something recently on the particular way that the vehicle flies. So yeah, it's a pretty diverse interest, really. And we were at DroneX earlier in the year, and that you can see there the diversity of what people are interested in and where they're working. So yeah.
And are you finding that companies are approaching you with patent ideas at the design stage? For example, I may not have even built a drone or a piece of software yet, but I've got an idea for what it is. Or often it's people that have developed a piece of hardware, a piece of software, and then they're retrospectively coming to you to say, we've realized this is an important thing and therefore we want to patent it. Yeah.
So both. And there is probably a sweet spot in terms of coming to see us, the moment to come and do that. The critical thing is not to disclose your idea to the public. So that essentially beyond yourself or beyond your organization, before you've applied for a patent, if you want one, because that destroys the novelty of your idea, and in most jurisdictions stops you getting valid patent protection. So that's you don't want to be so late that you've missed that. You don't want to have already disclosed it and sort of started marketing, nothing like that. On the other hand, you don't want to be so early that the idea isn't mature enough that you could describe it in a way that somebody else could then implement it. because that's what we're going to have to do within the patent application, or part of what we're going to have to do is describe and define the idea in a way that a third party could then, a skilled third party could then take it and implement it.
And do you find a lot of companies just go for, you mentioned obviously you can start with a UK patent, or most organisations that are coming to you are recognising this is, the drone industry is not just UK, it's European, global based. And a kind of, are there certain market, you might have to explain a bit kind of what we mean by the UK, international, European, in terms of you can choose different sectors. But what markets are they looking to get patents for? And do you find, for example, if I get a UK patent, that's already covered, somebody else has already developed a European equivalent, therefore that is non-patentable?
Yeah. So the patent system across the world is really very well harmonized. There's very minor differences between the countries, but the vast majority of the fundamentals are very fixed and similar. So that means, generally speaking, that you're not going to get patent protection for something in the UK, but then you can't get it in Japan or something like that. They'll all be looking at, for the most part, the same prior art, the same material that's out there in the world. So that's the first thing. Yeah, sorry, what was the other part of your question?
It was around, very much kind of the process that people might go through is whether you start in the UK, do I start in Europe?
Yes, fine.
And kind of the kind of rollout about how you go about doing this in the first place.
Yeah, so a very standard approach for let's say a UK client coming to us is to apply for a UK patent first. That's because you get a pretty good search from the UK Patent Office, and it's relatively cheap. And you do that. So the point of having a good search is that it then can inform your prospects for getting patent protection, or the scope of patent protection that you're likely to get in the UK, but also further afield because of that harmonization, essentially. So with the benefit of those search results, you then can take the decision as to whether or not to file abroad.
And then once I've got a patent, sorry, go ahead.
Yeah, so you have 12 months basically from the filing. Let's say we take this approach, we file in the UK first, which is not the only way, but it's a very typical way. File in the UK first, you've then got 12 months within which you can file patents abroad and still claim what's called priority back to your UK, so you get the benefit of your filing date for your foreign filings.
And once I've got a patent, is that it? Or do I have to, for example, pay for a renewal fee, something along those lines?
Yeah. So there is a renewal fee once it's granted. Varies depending on country, how much it is. It tends to be fairly small compared to even the cost of getting the patent, and certainly compared to the value of the invention that you've decided to protect normally. So in the UK, it's in the low hundreds of pounds per year, typically. So but there's obviously an initial cost around the drafting and filing process, which tends to be the lion's share of the cost. And then there's the cost associated with that prosecution phase that we talked about, that back and forth with the patent office. And that's a little bit variable because it depends how aggressive you are with the scope of protection you're trying to get. Depends what the patent office finds, so how many rounds of examination you go through, essentially. But that part, as we say, the patent office maybe on average takes 6 months per round of response, maybe more. So it is a multi-year process, so that prosecution costs tend to be spread over a period of 2 to 4 or 5 years.
What was the next part? If somebody challenges a patent, can that be done post-patent issuing, or that would normally happen during the 12-month process, for example? Sorry, the next part as well is bigger organisations, to my understanding, sometimes will just ignore a patent. You then, for example, challenge it and say you're breaking a patent, and then they essentially buy you off. Is that something that really happens in this space very often, or not as much as one expects?
Yeah, so you can challenge a patent both as essentially the patent office is challenging the patent while it's going through prosecution, but there are opportunities to challenge it as a third party as well during that process, certain parts of it. And then also, as you say, post-grant, there's the opportunity to challenge it. So very few patents are actually litigated. Their best worth really is as a deterrent. But for those that are a very typical way that, there'd be a negotiation beforehand. There'd be some discussion around whether or not the patent is being infringed, whether or not the patent's valid. And if it actually got to court and there was a litigation, a very typical set of circumstances is one side alleging that there's been infringement of its patent, and the other side will typically allege that they're not infringing the patent and that the patent's invalid. And so that's basically the crux of the argument that then occurs in court. And obviously, yes, so there can be the kind of negotiation that you're talking about, because litigation is obviously expensive, and it's, if the parties can determine ahead of time that one side or other is in the wrong and they can reach a settlement between them or a compromise, then that's better for everybody, really. So yeah, the settlements definitely can occur. And obviously, if you've got a big patent portfolio yourself and then somebody comes to you alleging patent infringement, there can sometimes be, especially with bigger companies, okay, maybe I'm infringing your patent, but maybe you're infringing mine, and so let's reach a better agreement.
Got you. In terms of, and I'll use some of my bad examples. Let's say, for example, I've got a patent on a piece of software which allows you to visually navigate using roads. But then I say I want to do a spin-off where it now visually navigates using railway lines. Once you have a patent issued in one area, does it give you more likelihood of kind of giving you a tangential patent alongside it, or it's essentially you're starting from square zero again?
Yeah, good question. So if you're within the first year of your initial patent filing, there's the potential to make amendments to your original patent application. So you might want to add in your railways at that point. If you're beyond the year, then you'd be starting from scratch with a new patent application. And if your first patent application is published, it would become prior art for the second one that you file. So in that specific case that you've given, I'd be a bit concerned as your patent attorney that potentially you're going to get a finding of it's non-inventive. You can imagine the patent examiner arguing, navigating by roads, navigating by rail, fundamentally the same things going on. We have to recognize a track on the ground. We have to then use that information to help us navigate and work out where we are. So very similar considerations. So yeah, even your own prior disclosures can be a problem. But so the inventive step hurdle is not particularly high. Most patents are granted to things that are relatively small iterative improvements on what's gone before. It's not usually something completely revolutionary.
Sure.
Yeah.
Understood. Those are most of my questions, John. Have you got anything kind of that you think I've missed? Anything you'd like to kind of cover from a more generic perspective?
No, I think you've done a fantastic job. I think that's hopefully we've given a good introduction to the system and how it works.
Perfect. And if members want to get in touch with you, John, anybody who's watching this, how do they do that?
So probably the most reliable way is if you go on the HGF website and search my name, which is John Hawtree, and there are plenty of aerospace related colleagues that we also work with, which will be visible on the website as well.
Perfect. And that's www.hgf.com.
HGF.com, yeah, that's right, yeah.
Perfect. Otherwise, thanks everyone for joining. Thank you, John, for coming on for this conversation, and I hope you all found it interesting and look forward to talking to you on another fireside chat soon. Thank you, everyone.
Thanks, Alex.